Good morning, everybody. Again, my name is Patrick Fife. I'm LIBOR's General Counsel. Welcome to the October 2025 legal update. So with that, I do like to start every class just to remind you that you need a resource to stay on top of all of the changes that are happening, all of the new risks that pop up in our industry. There are a lot. I hear from a lot of you that it's frustrating. There are so many changes in laws. There are so many new risks to our industry, and you're right. It's every industry, but I think this industry, real estate in particular, it is so highly regulated. We live in a state, New York, that constantly changes its laws. Got complicated jurisdictions within the state. You've got cities, you've got counties, you've got towns that all have their own regulations. So it's really important to have a reliable source to stay on top of things. And we here at LIBOR try to be that for you. We give you a lot of information that you can trust. I will caution you that there's a lot of misinformation out there. A lot of so-called experts on social media who put things out that aren't always right. So, what we try to do here is give you the right information when it comes to legal issues, when it comes to risks that you should be aware of. So check out our website, lirealtor.com. That's where you want to go to find, if you don't already get our weekly email, every Thursday we put out a legal tip. That I cover a lot of the information that's that's coming to you and that you need to be aware of. If you're a broker or an office manager, go to the website and check out the broker portal. There's a lot of good resources for you to use within your office to help train your agents. Please also look out for our events. This class we give every month. A couple other things just to note that are coming up for you. This one's not really for you, but if you work with any attorneys regularly, please let them know on November 5th, which is Wednesday. We are doing with the Nassau County Bar Association a hybrid presentation to go over what the attorneys need to know about the changes to commissions and the fact that commissions aren't on the MLS, and that if there are agreements between the seller and the buyer to cover commission for one of the parties, how the attorneys should structure that in their contracts of sale. Really important for the attorneys to know, because if they mess that up, not only are you potentially as brokers at risk of not getting paid, but they're going to have unhappy clients who may look at them as the reason why the transaction went bad. So we're putting on a program. It's November 5th, 12:30 to 1:30. It's both Zoom and in person. It's continuing education credit or continuing legal education credit for attorneys. So please let the attorneys out there know if you work with any. Really important for them to sign up. Also, another program I just want to let all of you know, Wednesday, November 25th at noon, we have a webinar with the New York City Department of Social Services to talk about the statewide city FEPS voucher program. It's going to be geared specifically to brokers and agents. Questions about voucher programs, specifically that program, but how your clients can work with that program. It's coming straight from the source. So really another good program, especially if you work with rentals. It's actually a New York City program, but it allows for the placement of tenants on a statewide basis, not just within the city. So really good thing for you to know about there. I mentioned our website, lirealtor.com. Please go check it out. A lot of great resources, access to all the legal tips, the documents on demand, our dispute resolution center, which includes how to file an ethics complaint, how to file an arbitration. Also, if you have a dispute with another realtor, you don't want to file an ethics complaint, but you're looking for a way to avoid that dispute before it becomes a problem. We have an ombudsman program. It's free. Go check it out. We resolve probably 8 to 10, sometimes even more, disputes per month between realtors that avoids the need for an ethics complaint, that avoids the need for an arbitration. It's a valuable program. It's free to you. Please feel free to check it out. And the last thing I just want to make you all aware of, if you're not already, is that LIBOR has its own legal support center. We have a attorney who's available 9 a.m. to 5 p.m. Monday through Friday to provide you with information on real estate matters. This is in addition to the NYSAR legal helpline. You still have access to that as a NYSAR member, but this is exclusive to LIBOR members. And you can call it again anytime, 9 a.m. to 5 p.m. And the number is 631-661-4800, and it's extension 335. And that leads me to the first topic I want to cover. And if you've taken this class before, you know that I try to go over some of the recurring questions that have come up in the last month to the Legal Support Center. So we're going to jump right into the first question, which has come up a lot. And that is, can a landlord charge more rent for tenants who have pets? Some of you might say, no, you can't. The answer is yes. When it comes to a pet, a landlord can ask for more rent. All right. But remember, this is the carve out. Service and emotional support animals are not, hey, we need everybody to stay on mute. Sorry. All right. Service and emotional support animals are not pets. Okay. They are considered a tool for somebody who has a disability, an accommodation for someone who has a disability. So if a landlord is charging more rent for pets, they can't apply that to a service or emotional support animal. Also, landlords cannot charge an extra pet deposit if they're already charging a 1-month security deposit. That is because in New York State, the most a landlord can charge for any rental, any residential rental, is 1-month security. Total 1-month security, no more. So if a landlord already has a 1-month security deposit, they can't charge a security deposit for pets. They can, again, increase the rent, but that rent increase can only be for pets, not for service and emotional support animals. All right. Another question that came in this past month, I think it's come in a couple of times, is how do I become an office manager, or are there qualifications for making someone in my office an office manager? Let's say I'm a broker. I want somebody to serve as my office manager. Can I just make anyone in my office an office manager? I think this particular agent's great. I want to make them an office manager. There are qualifications in New York State. You must be a licensed associate real estate broker. You have to have been active as an associate real estate broker for at least 2 of the last 4 years. This is a state law. You have to meet those requirements. You're also required to exercise the same duty of supervision over salespersons and associate real estate brokers as the licensed real estate broker. So that is your obligation. Once you're an office manager, you have the same duty of supervision as a real estate broker, and you can be charged by Department of State for failure to supervise. All right. Another question that comes up and has come up is, can I share another agent's listings on my social media page? Answer's clear on this one. No. Not unless you have the written permission of the listing broker. This question has come up in many ways, and somebody says, well, what if I'm actually friends with the listing agent? I'm friends with them on social media. Let's say it's Facebook, or I follow them on Instagram, and I'm just reposting what they posted. Just kind of doing them a favor, or just trying to call attention to their listing. Same answer. The answer is no. Unless you have the permission of the listing broker who owns that listing, you have no right to share someone else's listing on social media or anywhere else. That is the listing broker's listing. They control how it gets advertised, and you do not have the right to advertise someone else's listing. And sharing a listing on social media is considered advertising. So even if it's your best friend, or a listing in your neighborhood, and you just want to let people know that there's an open house that they're advertising. Can't do it. Not unless you have the written permission of the listing broker. It's an unfortunate question that we get. It's every industry, but sometimes people speak poorly about each other. My advice always is, if you don't have something positive to say about someone, just don't say it at all. Nobody is going to hire you because of negative comments you make about someone else. But we've gotten calls, and another realtor's making disparaging or false comments about me on social media. They're criticizing my business practices. What do I do? What can I do? Couple things you can do. Number one, document everything. I would always say, if somebody is, whether it's a customer or a client who's making a false statement about you, you always want to document everything. Keep a record, take a screenshot. That's one. Two, contact the broker or have your broker. If you're a salesperson, let your broker know that somebody's making false statements about you, and they can contact the broker. Oftentimes someone else's broker doesn't realize what the agent is doing. And once they realize what they are doing, they'll take care of it, because whatever that agent does reflects poorly on them and can even lead to liability for the broker. So that's the second thing you can do. The third thing I would recommend is you contact LIBOR's professional standards department. I mentioned our dispute resolution section on the webpage. But you could file an ethics complaint, but you could also ask for an ombudsman, which is really just it's a fancy word for another realtor who's a trained third party who tries to help resolve disputes and enhance communication. So it's something I've seen it done in cases where we've had, a realtor talking bad about another realtor or poorly. The ombudsman's kind of explained to them that this is a concern of another realtor. They don't take sides, but they say, look, this could potentially lead to an ethics complaint. So why don't you just consider withdrawing the comments or backing off? And something like that can resolve it. If not, I mentioned you can file an ethics complaint. Remember, Article 15 of the Code of Ethics that applies to all of you as realtors says that you shall not knowingly or recklessly make false or misleading statements about other real estate professionals, their business, or their business practices. So that is what I think the best practices would be if you encounter this situation. Another question that comes up frequently has to do with estates and trusts also, about how you take a listing in that situation. But you often may get a call from someone who says, my aunt, my mother, whoever it is, just passed away. We need to sell the house. Estate hasn't been set up yet. It hasn't been probated, the will, but I'm named the executor in the will. Can we put the house on the market? No, not yet. You need to follow the proper process. Otherwise, you don't have a valid listing, right? As part of when someone passes away with a will, the will has to be probated through surrogate's court. And the court issues something called letters testamentary that confirms, hey, this executor named in the will actually has the power to act for the estate. So you need to request copies of those letters testamentary. If the person dies without a will, there's letters of administration, but you need to have something from the court verifying that you are dealing with the court-appointed representative of the estate. If the court has not appointed that person, you need to let them know to meet as soon as possible with an attorney, so that they can get that process underway. And that you can then take the listing. If you take a listing from a proposed executor, technically you have an invalid listing. You could basically be at risk of never getting paid. And also that whatever contract, the attorneys are not going to let a contract be signed by the proposed executor. So encourage them to speak to an attorney. Another area of some confusion that comes up a lot, and this I checked came up I think 3 times in the last month, calls about the property condition disclosure statement, and who needs to sign it or when it needs to be signed. It needs to be signed by the seller and completed by the seller, not you. The seller has to complete it, but it's a seller of residential real property. And residential real property is defined as real property improved by a 1 to 4 family dwelling. So that does not include vacant land and does not include condos or co-ops. So condos, co-ops, vacant land do not require a property condition disclosure statement. Are there other exemptions? Yes, there are. There's many other exemptions. There's 14 of them to be exact. You've got bank-owned properties, court-ordered sales, fiduciary sales, meaning an executor of an estate, a trustee of a trust, do not need to complete a property condition disclosure statement, and new construction. If questions come up about, well, I'm not sure, does this need a property condition disclosure statement or not? You need to tell the seller they have to consult with their attorney and get guidance from the attorney about whether or not it needs to be completed. A couple more questions, and this one comes up a lot recently, and really probably in the last year. So somebody who calls in and says, well, I'm a buyer's agent. My offer to the seller or the listing broker included my compensation as part of the buyer's offer. Buyer and I had an agreement to pay me X%. Buyer said, I want you to include that as part of the offer, that the seller is going to cover that as part of from the proceeds. And I included that in my offer, and the offer was accepted. And now the seller's refusing to pay my commission at closing. That's what I've learned. Well, first question would be, well, did you make sure that the seller's payment of your compensation was included as a term of the contract of sale? Just putting it in your offer is not enough. You've got to make sure you have a confirmed written agreement by the seller to actually pay that as part of the transaction. If it wasn't in the contract of sale, you have a separate written agreement confirming the seller's agreement to pay. That's what you need, folks. It can't just be the fact that I included it in my offer. If neither of those things exist, the seller probably has no obligation to pay. Your only recourse would be against the buyer under your buyer rep agreement. And I'll tell you what, if it was your failure to make sure that you got the seller's written commitment, the buyer's probably not going to want to pay you either. Because if the buyer thought that you included that and you secured the seller's agreement to pay compensation and you didn't do it, that's going to be a problem for you. So you want to make sure a seller paid compensation, if it's the seller's agreement to pay, that it's included in your offer. You include it in your sale memo, your deal sheet, whatever you send to the attorneys, and that it then becomes a term of the contract of sale. So I mentioned that class that we're giving for the attorneys, did one for attorneys in Suffolk County, written articles about it. We've put out flyers that you can give to the attorneys. The attorneys need to be aware that if the seller's agreeing to pay the buyer agent compensation, it should be part of the contract. It's no different than any other term of the contract. It protects the buyer, but you've got to make sure that you have that written agreement. I've heard too many agents out there think, well, I put it in my offer, I'm good to go. No. Back when we had compensation in the MLS, that was your contract. We don't have compensation in the MLS anymore. It's not just a field. That field represented a contractual agreement. Because that's not there anymore, you need to have a separate agreement somewhere showing or indicating the agreement of the seller to pay the buyer agent's compensation, if that is in fact the term of the deal. So, please make sure that you understand that. I think last question I have here on the from the legal helpline is, we've gotten a couple times, well, what's the difference between a buyer's agent and a broker's agent? You hope you know this. It's on the agency disclosure form, and you should be able to explain it. But the buyer's agent works directly with and represents the buyer, period. Broker's agent, they represent one of the brokers. They don't work for the buyer. A broker's agent is engaged by either the most often by the seller's broker. It can be by the buyer's broker, but you're assisting that broker with the transaction. You do not have a relationship with the buyer or the seller. You are working for one of the other brokers in the transaction. Your primary client as a broker's agent is the broker that is your principal who hired you in effect. When you're the buyer's agent, your client, the party who hired you, the principal is the buyer. And just a reminder, you can't make yourself independently a broker's agent or a buyer's agent. I always joke around. I can't just say I'm coming out this morning and I'm going to put my broker's agent jacket on and I'm going to be a broker's agent. You don't have the right to do that by yourself. Who makes you a broker's agent? Another broker from a different firm. So, firm ABC says, I'm interested in having a broker's agent, and they offer broker agency out to firm XYZ and say, hey, firm XYZ on this particular property, I'm open to having a broker's agent, and maybe they're willing to pay compensation to a broker's agent, but it has to come from the broker who's offering out agency. I can't make myself a broker's agent. Someone else has to anoint me or give me that authority, another broker. So that's a key difference for you to understand. All right, so we're going to move into next topic, which is cold calling. There is still a cold call ban in effect right now. Remember that we have something in New York State, a general business law that prohibits unsolicited telemarketing and sales calls to members of the public during a declared state of emergency. You might not realize it, but we are under two declared states of emergency here in New York. There are one set to expire November 2nd. It's federal actions related to vaccine mandates, and the other has to do with public order at correctional facilities. They're both in effect. These may be extended, and until they are either no longer extended and we're no longer under a state of emergency, cold calls by anybody in New York State are technically not permitted. And any other type of marketing is allowed, but cold, unsolicited phone calls or text messages to members of the public, not to other businesses, but to individual members of the public, are not allowed. And I've heard some people say, well, Patrick, you know what? You're kind of overstating this. Yeah, this is a law that no one follows. I get cold calls all the time. I do too. But the difference that I keep reminding you is that you have a license from the state that permits you to do business. It's your lifeblood. Without that license, you can't do business. And the Department of State is enforcing cold call laws. And they have reportedly been enforcing violations of telemarketing laws, including calls made during declared states of emergency. And it can lead to possible fines up to $20,000 per call. Learned that Department of State is seeking to hold brokerages liable for calls made by salespersons. And in one instance, Department of State is seeking to hold licensees collectively liable for $13 million in connection with over 250 allegedly improper cold calls. So just be aware that this is a real thing. It can lead to liability. And so until these states of emergency are over or the law is changed, we can't make cold calls. That is the law. I don't like the law. I don't think it's a good law. There have been attempts to try to get it changed, but that's the law right now. We also have a law in New York that says once you are allowed to make telephone calls, or cold calls, not telephone calls, there is a process you're going to have to follow. This is the so-called Seinfeld law, because there's a cold calling episode in Seinfeld, if you remember, where Jerry had asked the caller for his own home phone number so he could call him back. But once cold calls are allowed, you're going to have to follow a very specific script, stating your name, stating the company you represent, disclosing the purpose of the call. You have to reveal if the call is being recorded and give the call recipient the option to be placed on your internal do not call list. So be aware of that. There's also the do not call registry in New York. Remember that once cold calls are allowed, you still have to follow this. If someone is on the do not call registry for more than 31 days, you are not allowed to call them. Department of State will also enforce violations of this as well. So my bottom line for brokers is have a cold calling policy in place. Remind your agents what they are and are not allowed to do, and remind them when they cannot make cold calls. I do see a question about cold calls. Does this include Zillow lists or previous contacts? Unless you have a pre-existing business relationship with that party, that would be considered a cold call. So yes, if you get a list, let's say, of hot leads or something like that, that would be a cold call. That wouldn't be allowed. If you have an ongoing or a pre-existing business relationship with a particular party, that's a little bit different. That would not be considered a cold call. Calling expired listings that were not your client, that would be considered a cold call. That would not be allowed. So there is a risk, especially if somebody reports that call to the Department of State. Again, Department of State may take action on it. I just, the tone in the laws that have come out are very anti-cold call. And I know it's frustrating, but you also have to think from your perspective. I know all of us get a lot of cold calls, and it's usually frustrating. You don't like them. I think that's sort of the way that Albany and Washington, D.C. look at these as well. So there are laws in place. You do need to follow them, and they can impact you, especially because we are a licensed profession. The person selling solar panels or car warranties or something like that, they're not licensed. So yes, they're at risk, but you have a bigger risk in that you have a license that you want to protect. Another question that I'm going to try to be quick about this because it only applies to a small segment of our groups, our members that are here, but it's important for you all to be aware of, and also it's something that we've gotten a lot of calls about, even in the last month. It's the New York City Fair Act, the FARE, Fair Act, and that is the law. It went into effect over the summer, and it prohibits New York City only residential in New York City landlords from passing the fee of the broker they hire. So the landlord's broker cannot be passed on to prospective tenants. So the only person that can pay the landlord's broker is the landlord. Landlords in New York City cannot ask tenants or require tenants to pay their broker fee. It only applies in New York City right now. There's talk in Albany of making a broader law across the state. But right now, it applies only to properties in New York City, residential properties in New York City. And the key thing to remember is the landlord's agent cannot collect, impose, seek any fee from a tenant related to the rental of residential real property. So there's no workaround. You can't disguise the fee as something else. Any fee paid to the landlord's agent in a residential lease in New York City must be paid by the landlord. That's probably the simplest way I can put it. Once you look at it that way, it's pretty simple and easy to follow. Landlords agents can still get paid. They should have a compensation agreement with their landlord. So whatever listing agreement the landlord's agent has with the landlord should make very clear that they are getting paid by the landlord. If you're working with leases in New York City, check the agreements you're using. Make sure they've been updated. Some of you may be using agreements that still say the tenant's going to pay the compensation. That's not legal. It could void the entire agreement. You could basically be working for free. So make sure if you're taking a lease of a property in New York City that your listing agreement requires the landlord to pay you the compensation. This also applies to open listings. So remember, an open listing it's not exclusive. Essentially, the landlord could be going out to broker A, broker B, broker C, broker D, hiring them all and saying, first one of you that brings me a tenant, I'll pay you. But I'm not working with any of you exclusively. I'll just give you the right to advertise this listing. In that case also, that agent cannot be paid by the tenant. That agent must be paid by the landlord. All right, very simple. Co-broke restrictions. So same thing. You can't have the tenant's agent basically share their compensation back with the landlord's agent. Landlord's agent can only get paid by the landlord, not the tenant, not the tenant's agent, strictly by the landlord. Tenant's agents can still get paid by the tenant. So you can work as a tenant's agent. You can collect fees from a tenant, provided the tenant has hired you, you're working in the best interest of the tenant. I would strongly recommend, whether you're in New York City or New York State, you want to have a written agreement with your tenant. This is not required under the NAR settlement. Remember, NAR settlement pertains to purchases, right? And you need to have a written agreement with any buyer before you tour a home. But I don't see any reason in this day and age why, if you're going to tour a apartment with a tenant as a tenant's agent and you provide them that agency disclosure form, you really should have a written agreement with that tenant, letting them know what you are going to be paid for your services. It can be exclusive, it can be non-exclusive, but very important. So there's no, full transparency, no misconceptions, no misunderstandings, what you are getting paid and who is paying you. You want that made clear. Dual agency is still allowed in New York City. Landlord, tenant, rentals, but you make sure that if you're representing the landlord has to pay you for the work that you are doing for the landlord. Your fee cannot be paid by the tenant. If you are going to be working for both, you need to make sure that you have you've confirmed that you've provided a dual agency disclosure, informed consent from both parties, that both parties understand that you are representing each party, that you can't give your full committed duty of loyalty to both parties. You want to make sure that you've provided them that written understanding and full disclosure of what you're doing, who you represent. And you also need to make it clear in writing that you are being paid a separate fee by both the landlord and the tenant for the separate services required to each. So again, you cannot have the tenant pay you for the share of work that you're doing for the landlord. That work has to be paid by the landlord. You're only going to get paid by the tenant for whatever services you are providing to the tenant, and you still need the full informed consent of both parties. The FAIR Act also has a fee disclosure requirement. So I see a question about third-party rental compensation. That's going to come up next. So good question. But one other point on the FAIR Act that everyone should know about, there is a fee disclosure requirement. So all listings have to disclose upfront any fees that are going to be charged to the tenant in connection with the execution of the lease. And then before signing the lease, the landlord or their agents has to provide an itemized written disclosure of all fees. That disclosure has to be signed by the tenant prior to signing the lease and retained for 3 years, and a copy has to be given to the tenant. Potentially big penalties for this. I will say that the penalties, say big, they escalate. You can be fined for each violation, and the fines escalate as to the number of violations. Civil actions can also be brought by someone claiming a violation. And also remember, I keep getting back to you hold a license. Department of State can also sanction you fine you, seek any kind of licensing, suspension or revocation for failure to follow a law. And that would even include a law like this that pertains to New York City. So take this very, very seriously. This question just came up in the chat. So does the FAIR Act prevent the landlord's agent from accepting a broker fee from a voucher program, right? I said you can only get paid by the landlord, but what about from a voucher program? I hate to give this answer. It's not entirely clear yet. We've been trying to get a clear answer from the different New York City programs. I'm hoping to gain some clarity at the webinar that we have coming up next month. But look, I will say this. The law clearly says you cannot seek to impose a fee or collect a fee from the tenant, right? So you never want to ask a tenant, even a tenant in a voucher who has a voucher for demand that their voucher program pay you the fee as the landlord's agent. If the program offers to pay the fee and they say they are permitted to do so, you want to make sure that you get the voucher program's position in writing, basically saying, we, this program, are agreeing to pay you, the landlord's agent. So I would just caution, if you're the landlord's agent, don't demand that the voucher program pay the fee. Don't require it, as that's going to create a problem for you. But if the program does offer to pay, and they say they are permitted to do so, you just want to make sure that you get that position documented in writing. I hate to not be able to give you a entirely clear answer, but it's a bit of a gray area right now. But I think you are as protected as you possibly can be if you get the voucher program's commitment in writing, to basically voluntarily be making that payment, to cover the landlord's broker fee. All right, we're going to move now. This covers everybody. These are just some advertising best practices that I always like to go over. I strongly encourage you all, after today's class, to look at the New York State advertising checklist that was part of the email that you got for this class. It's one of the handouts that was provided. It's the checklist that the Department of State uses when there are advertising, when they're looking at someone's advertising. And I will tell you that anytime there is a complaint brought against a licensee for any reason, even if it's a unverified complaint, they will look at that licensee's advertising. They also get anonymous calls about advertising. They also look at advertising on their own. They do their own, searches of the internet. And they always are going to use that advertising checklist. So I encourage all of you to take that checklist and periodically, have a system twice a year. Just look at all your advertising and run down the checklist. And advertising, it means everything. It doesn't just mean your website. It means everything related to your licensed real estate activity. So if it's your email signature, it's your website, it's your, your telephone, your anything you have, your business cards, your signs, if you still use flyers, your print ads, your digital ads, whatever it is, that's considered advertising. That just fall within the check. Make sure everything you're doing meets the checklist. It's not that hard to do, and it will save you thousands of dollars if for any reason you wind up in front of the Department of State. I like to do this usually on an in-person class, but I have this up here. How many errors, or not errors, but how many licensing violations, are advertising violations are on this particular card? You look at it real quickly and you're like, yeah, this looks fine. There are at least 5 advertising violations on this card. I don't know if anybody in the chat wants to try to identify any of them, but there are at least 5. And there's also the improper use of the realtor mark, which is a separate issue, but that could be a violation of your membership obligations to LIBOR. Yeah, somebody right here, you need an address location for this card. I either need my office address or I need my office phone number. I need one or the other. Right here, I don't have it. I just have a cell phone number. Correct. No broker information. That is huge. Every advertisement you put out there as a salesperson, associate broker, whatever, even a broker, you have to put your broker's name. And I put here the Long Island Dream Team, right? You could be on any team you want. You could be on the Yankees. I don't care. And you could put that on your card, but you still have to identify your broker. A team is not a brokerage. A team is just basically something in the licensing regulations for advertising purposes. You still have to identify your broker. I could likely call myself the Dream Team. I'd have to do a search for that and make sure I'm not conflicting with anybody, but I've got to identify my broker. So that's, yes, Marie says license type, right. There's no such thing as an associate broker. It's an associate real estate broker. I don't have to use the word licensed. That's optional. You can, you cannot. License number, you can include it. You don't need to. I would just think it's clutter. I mean, certainly I'm not advocating that you don't need to put it there, but it's not required. Damon, yeah, very good. The title, right? I can't, as an associate real estate broker, I can't use a title. Salespersons and associate real estate brokers cannot use corporate titles. You have to be the broker of record or owner in order to hold a corporate title. So even if my broker thinks it's great and thinks I'm great and wants to call me the corporate vice president of my brokerage, can't do it. Big problem right there. Last one on there. You probably wouldn't know because you don't know me that well, but my license, I am not a licensed broker. I don't have my broker's license. I am an attorney. And my name for my admission to the bar in New York State is not Pat. It is Patrick. So yes, Selwyn says name as licensed. That's correct. It's not there. So somebody who had, let's just say I had a complaint against me, right? And it was completely unfounded. Let's say Marie Selwyn, somebody reported me to DOS and it was completely false. They just, I'm vindicated entirely, but Department of State said, you know what, Patrick, we'd like to see your business card and your advertising. And I gave this to them. They'd probably fine me at a minimum $2,500, maybe more. And they'd also look at all my other advertising. And so you could see how things rack up quickly. And if I'm a broker and I've got a bunch of agents doing this, and there's some kind of complaint about my website, and they look at every page on my website, and every agent has corporate titles or the wrong license type, it can lead to really big money fast. So just get your advertising in order, do an audit, follow all of the necessary steps. Not only does it potentially save you money, it will make you look that much more professional. I always say doing it the right way has that added benefit of making you look credible. It makes you look professional. There's a method to it. And so I would encourage all of you, especially on social media, you don't want people to have to try to figure out, is this person like, are they real? Are they a scammer? Because if you don't put all of that required information and you don't do it the right way, you may come across as someone who is looking like a scammer or not a legitimate real estate salesperson. So really, really make sure that you've done it right. Grace had a question about including middle initial. If your middle initial is on your license, look at whatever you've got on your license from New York State. Whatever your license name is, if you've included a middle initial, you want to include that on your business card and your advertising. All right. Copyright infringement. This is just something I like to throw in there. Be very careful about use of photos that you did not take or you don't have permission to use. So you can't, I know it's so easy to just like right click and copy, and I'm going to put this into my Instagram post. I'm going to use this beautiful house to kind of as a backdrop, a green screen backdrop, or I'm going to use Canva and I'm going to throw that photo in there and make it look like I'm in front of this multi-million-dollar house. there are real risks. You could be sued for copyright violation. You need to have either taken a photo or have the owner's written permission before using any third-party content in order to use that photo. And I will tell you that I know a lot of you say, well, Patrick, no one's going to figure out, it's just convenient. I'm not hiring a photographer to do whatever for my advertising. It's AI. I know a lot of you use AI for your business. There are people that use AI now to search the internet for copies of photos that copyright holders own. And they go after people like you, like other real estate agents who are using photos without the copyright holder's permission. So AI is being used just for that purpose. And there are businesses, there are real estate agents who are getting demand letters, getting sued for using someone else's copyrighted work. And the AI doesn't say, well, John Smith is just a second-year real estate salesperson. No, they don't distinguish. They go after anyone and everybody who violates someone's copyright. So please just make sure you're careful about the photos that you're using. Don't just use photos off the internet. You want to make sure that you're getting permission before you're using photos. Stock photos are fine as long as they come from a program that you have a license to use those photos. So like the photos that are in this presentation, they are stock photos that come from a subscription that LIBOR has. And we have the right to use those photos. So you can use things like that, but you need to have the legal right to do so. Another just quick tip, make sure that your website has a link to your broker's website. So every website that you have should always have a link to your brokerage's website. Just like you need the brokerage's name, you want to have a way to link back to the broker's website. Because you as a salesperson, just remember, or an associate broker, you don't have the right to really advertise on your own. Your advertising is always an extension back to your brokerage, and brokerages need to know the same thing, that their licensees advertising is an extension of them. They can get in trouble for their licensees advertising. So it's really important for both the salesperson and the broker to know that their advertising needs to be consistent and always tie back to the brokerage. All right, I did a legal tip on this last week. It's something that we've gotten a couple questions about. I know NYSAR had gotten questions about. There's something called the Consumer Review Fairness Act. It's not the FAIR Act, right? This is the Fairness Act. I guess the legislators really like to use the word fair in legislation, but this one is nothing to do with broker commissions. The Consumer Review Fairness Act is actually a federal law. It's been in place for almost 10 years, and it protects a consumer's right to share honest opinions about a business. This applies to all businesses, not just real estate, but basically it's giving consumers the right to express their opinions without a fear of retaliation. It includes opinions about products, services, conduct, in any forum, including social media. And all of you provide service. I know you don't provide necessarily a product, but you provide a service. So the public has a right to comment on their opinion about your services in any forum, including social media. And so the key provisions of this law pertain to form contracts. So our listing agreements, our buyer representation agreements, we use a lot of form agreements in this industry, which is a good thing. It's good because it's standardized for you, less likelihood of mistakes. It's good for consumers in a way that they can understand. They're kind of typically presented with the same types of forms. Well, form agreements cannot, under federal law, have any provision that restricts or penalizes reviews. So you cannot put a provision in your form agreements that say you are prohibited from making any comments about the services I provide, or impose penalties saying, you're going to be automatically responsible for damages of however many thousands of dollars if you make any comments or reviews about me online. Believe it or not, there are brokers who have tried to do this. But you can't. There's businesses. I'm sure you've probably signed agreements for other services that have had things like this in it. It's illegal. The federal government wants people to have the ability to comment honestly about what they feel a business is providing. You can't require them to transfer intellectual property rights or give up ownership of the content in their reviews. And you can't threaten legal action over negative feedback in a form agreement. So if you use any kind of form agreements, make sure you don't have these types of provisions. You want to review them. Things like non-disparagement clauses, they're kind of a gray area, but you want to be careful. You don't want to have anything in your agreements that looks like those types of clauses that are restricting somebody from speaking an honest opinion. This doesn't mean if somebody posts a negative review, you can respond. I would always encourage you to respond carefully, professionally, in a non-threatening manner. Again, I would think that you're smart enough to all know that a professional, thoughtful response is going to enhance your reputation and make it more likely you're going to get business, and that consumers see your responses. And no one is going to hire you because you really let that person have it online. It doesn't do any good. It may feel good for the moment you type that, but at the end of the day, legally and from a business perspective, not the smartest thing to do. Also, if you do get reviews that are false, defamatory, contain confidential information, you can still try to get those removed. You can challenge reviews. A lot of the online service providers, Google does have methods for you to challenge reviews. So this isn't to say that this gives consumers the license to speak falsely about you, but just make sure that you're aware of provisions in your form agreements that could potentially conflict with this law. Violations can be significant. Agreements that don't comply with the CRFA can actually be voided. So if you've got provisions that violate the law, it could void the whole agreement, which could mean that you be at risk of losing your commission. So just an important point to be aware of. Last topic that I want to cover in the last few minutes is just about lawful source of income discrimination. We did a program last week here at our Melville office with Long Island Housing Services. It's a fair housing program. And they do not all, but a significant amount of undercover testing for apartment complexes, also real estate brokers. They also handle complaints of individuals who are being discriminated against on the basis of lawful source of income. And they report that it still is a problem. It's something that I really just try to teach in every class, even if it's just for 2 minutes, so everyone is aware of what lawful source of income is and what they need to do to avoid discriminating on the basis of lawful source of income. So lawful source of income is a protected class. It does not mean that a housing provider can't ask about income or where your income comes from, or basically find out, does someone have the income to pay for an apartment? You could do that. You just have to accept all lawful sources of income equally. So I can't look at this list and say, I like people with a job better than people that get income from child support or foster care or vouchers. I've got to look at all the sources equally. I can't say, well, somebody might lose their child support. I don't like them. That is discrimination. It's also, short-sighted because everyone's like, well, I want someone who has a job. People lose their jobs all the time. A lot of these other lawful sources of income, like vouchers, are actually much more stable than somebody who has employment. But the bottom line is I've got to treat all these the same. I can't say I like people with a job better than people with foster care subsidies or Social Security. It would be no different than saying I like people who are a specific race, a specific religion, a specific gender better than another race, religion, or gender. It's discrimination. So think of it that way. And I give you just, I put these examples out there because it's still a problem in our industry. That's why we're just going to continue to educate on this. I don't want to see any of you wind up being the subject of one of these investigations, one of these articles, because you shouldn't be. It is so easy to avoid source of income discrimination, and there's a benefit to landlords to accept all forms of income. By not doing it, they're actually hurting themselves. So I just so you're aware, it's a problem. It's not something that's gone away. It continues to be a problem. And it looks like all of these types of things, failing to respond to voucher holder inquiries, saying we don't work with voucher holders, my landlord doesn't work with voucher holders, the apartment doesn't take voucher holders. This is my last slide. I know I'm at time, so I just want to kind of give these last tips, and these slides will be available to you when we post the class online. But just never turn away a prospect because they receive any kind of financial assistance or have a different source of income. You just treat everybody the same way. So if somebody calls up about an apartment, you always ask them the same questions, regardless of their source of income, right? You have standard procedures for every prospect. Just always ask somebody who calls, even if they say they have a voucher. Okay, what area are you looking in? How many bedrooms are you looking for? What's your price range? You treat them the same way you would anyone else. You show them the same apartments that fit within their range. That is providing equal services, having a systematic process for treating every person the same way. If somebody does say they have a voucher, there is some additional information you want to get because you do want to get a copy of that voucher. You want to find out more about their program. But with the exception of that, you just treat everybody the same way. Lastly, if you get an owner who says, I don't want to work with people who have vouchers, or I don't want someone on child support, you tell them, I can't do that. That violates the law. And if they say, well, then that's what you need to do. You work for me. You say, well, no, I don't work for you anymore. I'm terminating our relationship. Simple as that. You just walk away. You do not have to accept instructions, and you never should accept instructions from an owner who wants to act in violation of the law. So that's it. We're at 11 o'clock. All right. Thank you, everybody. Again, next month, this class is being offered again on November 25th. So feel free to, sign up. And if you also have any questions about any of the topics, just go at lirealtor.com. I think every one of these topics has been addressed, at least in the last couple months, in a different legal tip. So thanks again, everybody. Have a great day.